Welcome to We Chat Divorce, hosted by Karen Chellew, Legal Liaison, and Catherine Shanahan, CDFA. Each episode, we sit down with divorce professionals and industry experts to provide insights and frank discussions about real people, real situations, and real divorce to help you achieve your best life post-divorce. This episode of We Chat Divorce is brought to you by My Divorce Solution, offering divorce financial planning so clients can secure the divorce settlement they deserve. Visit mydivorcesolution.com to request access.
There's a side of divorce that rarely gets talked about, the part that unfolds quietly behind closed doors and often without witnesses. When harm isn't obvious or explosive, it's easy to question whether it even counts. But in family court, what isn't clearly documented is often treated as if it didn't happen at all. Welcome back to We Chat Divorce, brought to you by My Divorce Solution. I'm Karen Chellew, Legal Liaison, helping you navigate divorce with clarity, structure, and confidence.
And I'm Catherine Shanahan, Certified Divorce Financial Analyst. And at MDS, we believe preparation isn't just about finances. It's about understanding how systems work, how power shifts, and how the right information protects you when emotions run high.
One of the biggest pitfalls we see in high conflict divorces is assuming that the truth will automatically speak for itself, or that your professionals will make sure it's seen.
Yeah, unfortunately, what is the truth, right? There's your side, the other party's side, and then the third side. But if you're listening today and you're feeling overwhelmed, unsure about what matters, or frozen about what to document, just remember, you don't have to fix everything right now today. This conversation today, I think, Karen, it gives some clarity on, making sure you know what to document. What's the importance of what you're document? Is there an outcome that you'll receive from recording everything that's worth it to you? Or it's just kind of a pacifying thing to do? Like, where do you use this information? Because everybody wants justice.
That's so true. And there's so much information, right? So a lot of times you're instructed to journal, or you're instructed to save those text messages and emails, or you're instructed to do a lot of things with all of the data. What's important, what's not. And so if you can step back and think about, first of all, what outcome am I trying to accomplish? And for us, we see people wanting to go back 10 years and, decide where dissipation happened or where money was wasted or whatever. What's important to you, what your attorney is willing to advocate on, on what premise do the courts listen to that, and then formulate a plan to get that data in a place that's useful, not only to yourself, but to your attorney and to the courts. And I think that this podcast really does a great job in accomplishing that.
I agree. So if you want to learn how to get yourself organized for documenting things that you feel you need justice on, or you need to advocate for yourself, stay tuned.
Courtney, welcome to We Chat Divorce. We're really, really glad that you're here with us today.
Thank you for having me. I'm excited to be here.
Excellent. So for our listeners, and before we get started, Courtney Gilmartin is a family court strategist and the founder of Monarch Consulting Group, where she helps parents bring order and clarity to complex court situations. Before entering the family court space, Courtney built her career in the fast-paced startup world, where she specialized in scaling companies and managing complex projects under extreme pressure. So when Courtney found herself in a prolonged high conflict custody battle, she applied that same corporate rigor to her own case, approaching it like a project that required structure, documentation, and disciplined strategy. So today she preaches and teaches protective parents how to document coercive control and so-called invisible abuse in ways that are organized, credible, and usable in court. She's also the co-founder of New Jersey Protective Moms and played a role in advocating for New Jersey's 2024 coercive control legislation. So again, welcome, Courtney. And so let's start this discussion at the beginning. What made you realize that the way most people document their divorce experience simply does not work in family court?
Definitely my own personal experience. So I myself have had a 10-year, almost 10-year protracted post-settlement custody litigation. So we settled our divorce relatively quickly. I was smart enough to put my business cap on during the divorce and realize I needed to get in and out of it as quick as possible because every day that passed was money going out of our bank account. But after we settled, as many people find themselves trapped in litigation with high conflict people with personality disorders, the post-settlement litigation ramped up, and no one was really taking into account the behaviors that my ex was engaging in and the things that he was doing in a way that I felt as though they should have. My ex was very blatant in his behaviors and flagrant. He put it on full display, but it still wasn't really making a difference in terms of the protections that were put in place. So I really had to take a step back, peel off that emotional layer that so many people find themselves in when they're in litigation, especially if it pertains to assets or your children, and really take a look at the parallels in my professional experience and apply them to my personal experience. I had all this documentation, emails, texts, court orders, motions, certifications, all these proofs that no one really had the time to sort through. So I had to digest them down and drill it down into digestible bullet points with highlights where people could just, take a half hour, really read through and kind of get the dynamic of what was going on there and be able to help me and my kids.
Excellent. And a really a great offering to so many people, even beyond custody battles, even in the financial space of having to negotiate a financial settlement, being able to disseminate that in a way that the courts can digest it, to your point, is so important and very difficult for people to do, because in divorce, you're kind of like led by your emotions. And it's really hard to see beyond that, because, I'm going to guess what your attorney told you is just give me the information, right? There's no protocol or structure. You kind of have to figure that out yourself, and you don't know what's important, what's not important. So from your lens and your experience and your services, what do most people misunderstand about evidence in family court?
I think they just think that if they have it, it's going to make a difference. And while that's true to a degree, I think presentation is key. Being organized is also huge. And you have to look at the time constraints that are on most professionals in the divorce world, right? Lawyers have tens, tens of cases like yours, dozens probably, right? And then if you're going on to third parties, let's say like a parenting coordinator or mediator, or a GAL, whomever you have in your case, I'm just naming a few, they have endless cases just like yours, where everybody's coming in kicking, screaming, my ex is the worst, he's a narcissist, look at what he's doing. So you have to try to take all the evidence that you have and really make your case stand out. So I think people think if they come with it, it's going to make a difference, like I said. And their lawyers, a lot of lawyers will just say, just document everything. They don't give a framework for how to document and what to document. So people are just compiling papers and then they get into this like almost endless doom document loop, I call it, where they're just saving everything, but there's no method to the madness. So then it's almost stressing them out more because then they just have hundreds of text messages and emails saved to their computer. And let's say you're in the middle of a meeting with your parenting coordinator and they ask you a pointed question about January 1st. And you're like, oh, wait, 1 second. I know that something happened that day. And then you're going through endless screenshots or endless emails, you know, it kind of misses the mark at that point. You need to be able to quickly react and pivot and pull up and be like, okay, right here, I have this email. Do you want to take a look? And that really makes all the difference in your case because everyone's just drowning in paperwork in family court.
Yeah, and there's also another component to that that is never addressed. When the attorneys, you're right, they say document everything. But my question is always, and what will you be doing with this information? Like, what is my outcome for documenting this? Is it just to appease me because you don't want to hear from me for the next couple of months? Or if I put this all together, will there be a benefit to me at the end?
Right. And that's huge. And I always say to clients, it's not an exercise of utility to document and get everything together. It may feel like it in the moment, but to your point, especially if you have something that's really high conflict or post settlement, or you have someone that is just incessantly taking you back to court, you are without a doubt going to need proof and evidence. I don't have a crystal ball. I can't tell my clients, you're going to need a spreadsheet of disparaging emails for the parenting coordinator. You may, but you need all of the information in a sustainable and scalable, and that's also a big thing. Like some lawyers will give people the tools to do documentation on a really short term, but you need something that's going to last you the test of time. So you need to be able to put all of that stuff in one spot so that you can quickly go to your, I call it like a case hub. Like you need a master spreadsheet, a master document where everything lives and your evidence is directly linked to it so that you have everything in one spot, like I said, and then you can pivot. You can make a timeline. You could create visual exhibits if you need. You could pull, let's say you have every email documented on one spreadsheet and you label it disparaging or withholding information or whatever, because labeling is important. That gets down into like the more nuanced stuff. But then you can go in and you can filter out things. Let's say your lawyer's like, give me all the times that he didn't give you medical information. You could tag it and then you can filter and then you can just quickly extract it all and send it to them in a zip file. And that is so much more efficient than having to go through and keyword search and read every email. And then litigants are just getting re-triggered when they're doing that. So you need it all in one spot. That's like the first step.
Yeah, yeah. It's also a little, sorry, Karen. There's also a difference between documenting for custody and documenting for equitable distribution or community property division. And, one is more emotional than the other. And, we only stick in the financial world, right? So in the financial world, a lot of people feel like because their husbands or wives cheated, or because 10 years ago they did this, or 18 years ago they were in inappropriate situations, like whatever it is, the timeline there does matter. And
Yes.
that's where we get a little a little cautious when people are told to document all that, because to your point of what you just said, it does stir up more emotions. And what is the likely outcome of that information in the financial side of it? It typically doesn't go in the favor that you're hoping goes into it. It doesn't necessarily prove that they're hiding money or they've stolen money from the marital estate. And so I like the idea of documenting, but also having a realistic lens on what you're going to receive out of this work.
Right. And I think you can apply the same method to finances too, right? So my main focus, my first step, like I said, is just getting it all in a centralized location where the litigant or my client feels comfortable navigating that, because everybody has different capabilities as far as like technology is concerned, right? So how can we get it in a way where they're going to be able to feel comfortable to go and reference that information? And then really driving home the fact that time is money in the divorce world, right? So if you can quickly pivot and get people information, you're going to probably save money, save billable hours, or you're going to be able to strike while the iron's hot. You're going to be able to be much more effective, because the longer things linger, you're giving the opposing side time to like craft some lie or manipulation about what they're going to say and what they're going to counter. Whereas if you have the facts and the proofs right in your hand, ready to go, it's usually a much better outcome.
I know I'm going to share a personal experience here, and I won't call Karen my lawyer because I'm not allowed to do that. But my post-divorce, my first divorce, he brought me back to court asking for a dollar amount that was ridiculous and no grounds really for it other than emotions. But Karen really worked to timeline my emails, text messages, items, and I was my confidence came from having her on my side. It was great that she was my business partner and she could do this for me. But she kept me in my lane of being able to testify for myself. But I cannot tell you if it was once, twice, 10 or 20 times that we had to refresh my attorney. And by being able to just flip over a timeline that we already gave him all of those times, because they just don't look at it until the very last moment. But having it like that really made a difference, because I was able to push him on issues that he was not allowing me to push him on, because I had it all documented the way I did, because Karen did that for me. I
Yeah,
mean,
you're like
it really made a huge difference.
It did.
like
And
music to
well,
my ears.
Yeah, and he wasn't, and a lot, he wanted her to settle because he wasn't confident in the data. It's a lot of data. It's a lot, like, both of you, it's a lot of pieces that some of it, could make the judge think this is just tit for tat, or could make the judge believe that, this is something that really should be looked at. So in that space and connecting, all, what you do, Courtney, is do you work a lot with children, parents who are coordinating or trying to navigate through shared children expenses as they change across the years as they get older? Because I believe that too can become a place where the kids are left holding the bag because someone's not going to pay what they agreed to pay for, I don't know, whatever activity it is, whatever clothing it is. And then the parents are just at each other. And I'm sure for the parenting coordinators, this has to be very difficult and hard to navigate because I'm sure the parents' financial situations can change as well.
Yeah, and I normally work in dynamics where there's abuse going on.
Mhm.
Part of that is always 9 times out of 10 financial abuse. It's funny, a lot of abusers have like, I guess their currency, and I don't mean actual physical currency, it's what matters to them. Some of them will pay gladly because they don't want to look like a bum or a deadbeat or whatever. Most of them will not, they'll withhold. So clients usually come to me, I need help with my custody case. And then as we peel back the layers of the onion, yes, these expenses are always a glaring problem. And I ask them, well, how are you keeping track of all these expenses? And they'll say, well, my lawyer just told me to, go in OFW and send them a message with the receipt. And I'm like, that's great because our family wizard can be useful. But you need, again, a centralized hub, a timeline in chronological order every expense that you occur. And this is why I love Google Sheets or Excel. You can input formulas that automatically calculates how much they're supposed to pay of the expense and how much you're supposed to pay of the expense. And then you can hyperlink right to that spreadsheet, the expense proof. And then at the end of every month, you can just export it as an Excel file or a PDF, send it over to the parenting coordinator or your co-parent and request that reimbursement. And then it keeps you on the straight and narrow. It keeps you organized. It keeps you fact-based. You're not scrambling at the end of the year or the month, like, oh my gosh, I forgot this one, I forgot that one. It's much more sustainable. So that's usually a component that I work on too. And I've had so many clients, come back to me and say that spreadsheet, that template you gave me was so helpful because now I just plug in all the expenses. And then if they still don't pay and you have to go to court, I've never seen a judge or a court deny the use of that template and that spreadsheet because they like it because it's all organized there for them to see.
Yeah, that's great. And
Yeah.
it's tedious work, we all know, and nobody wants
Yes.
to go in and put all that information. It's like people that do the budgets with us and their lifestyle analysis. Nobody likes to do them. As a matter of fact, I don't like to do them. But it really, when the return on investment is that great, it's worth the agony. And the sooner you start and the more you keep up with it, the easier it becomes.
And
It's
to
great
your
to have
point,
that template.
yes, and I loved what you said before about it helped you testify. And again, having everything organized and documented helps so much because you can take off that stress and that spiral when you're stressing about what about this? What about that? I don't know the facts. And you can look at it and you can reference it. And to your point, you can email your attorney, no, please go look at line 110 on the spreadsheet or whatever you need to reference at that point. And then it's right there for them too. And I don't want to sit here and knock attorneys. They are just so busy, and most clients are coming in with just mountains of paperwork that they expect them to sort through. So, again, you want your case to stand out. You want to look different. You want to look more organized, more credible by default. And all of this work helps you do that. And it's going to help you stay rooted in fact. I have clients that have to go to trial and testify about finances, custody, whatever, abuse. And they will say having everything in a way where I can reference it, it jogs my memory. It takes out a lot of that anxiety because I can stay grounded in fact. And that helps a
Well,
lot of
yeah,
people stay regulated.
yeah, because fear is the driving factor in divorce. And when you can focus on what's known instead of all those unknowns, you really make a better advocacy case for yourself.
Yes.
And then everyone else can advocate for you if you're doing
Yes.
that on data and not emotions. And
Exactly.
that's the data that they need.
You're speaking my language. I love this. Exactly. And I feel like a broken record, but I'm like, especially if there's abuse going on or coercive control, that's so dysregulating. When people leave these relationships, they're like coming out of a fog. So, and grounding techniques do work. I'm not going to knock it, go outside, get grounded in the grass, whatever, that's different. But it's kind of like the same thing. I'm like, go get grounded in your spreadsheet. It sounds silly, but go take a look, go jog your memory, go look at all those messages, go look at the bank account if you're talking about finances. Go look back. Those numbers don't lie. The proofs don't lie. You can't gaslight a spreadsheet.
Exactly. It's even better when you show up so prepared and your other side is going there so cocky, like they don't need that information. And when you can turn around and present that data based on facts, you just look that much more what's the word? That creditable, right?
Yes, by
And
default. And you hit on another good point. A lot of these personalities, I don't want to generalize with gender, but a lot of the personalities are a lot of bark, no bite. So they get off and they control and they get their way. They're very coercive and they get their way with intimidation, or they yell, or they're loud, or they're angry, or they talk a lot. They don't say any words. And that is actually a successful tactic, right? A lot of them get by through life just fine and sometimes great doing those things. So when you come in with the facts and you can counter that, you kind of level the power dynamic, you level the playing field, and it helps litigants who are in, you know, I guess like the worst side of the power dynamic, for lack of better words. It helps them a lot in litigation because they don't come in organized. They come in yelling and screaming and stomping their feet and puffing their chest. They don't have proofs.
yeah, again, I'll go back to my case, Karen. Do you remember
That was
this?
a good one.
And
Yep.
you probably know what I'm going to say. So yeah, we had the barking on the other side, and we sat there, and I had my facts and my timelines and all of that. And he got so flustered at one point, he basically said, and I have the transcript because I know that you can go order the transcript. So if you want the transcript, you can go pay for that. And he said, "This is a game to me." He got so frustrated. He goes, "This is a game." So he literally said it was a game to him
Mhm.
because I never apologized for divorcing him. And that's what it came down to. But the sad part to all of that is leaving that courtroom. My attorney, that's the day he said I should just settle and give him half of what he wants. And I was crying, saying, "How dare you? I will drive back here. You just heard him call this a game. I'm not giving him a penny unless the judge tells me that." And I got the verdict. I didn't owe him a penny because I did come back. But
Good.
I wouldn't have been so confident. Yes, I know I do what I do, and everyone knows that I do what I do. But we also did an Instagram live showing me crying because it is a scary thing.
It
But,
is.
but if I didn't have Karen organizing me and putting it all in perspective for me, where I could keep myself focused on that, I could have caved. I could have also caved.
Yeah. And become a part of the situation that the judge is not able to discern anymore. Because I know Catherine and I wasn't there with her. I was just
Yeah,
waiting.
why didn't you go with me? Matter of fact, everyone, I want to know why Karen didn't go with me.
Because
Okay.
you were well prepared. But in any event, had she, um, or and Courtney, you can speak to this, I'm sure, but it's so important not to engage in the emotional back and forth, but to counter with the facts versus he's lying or she's lying or whatever the it may be, because that's what you're feeling. But your response has to be different than that, especially in a courtroom.
Karen, remember, I'm sitting on the stand with the judge there, and I'm sorry if I'm digressing, but I'm just sharing my personal experience. And I kept, your spouse with any kind of tendencies that they have without naming anything. You know how they talk and fabricate or what have you. And so, because I had the facts, I was looking directly at him, saying, "This is not true. Like, would you?" And then the judge said, "Ma'am, you cannot speak directly to him. You have to speak to your attorney. He's going to," and I must have done it 3 times. And then finally to the judge, I said, "Do you want to read the text messages?" He goes, "Ma'am, I cannot read your text messages. You can give it to your attorney," because you're sitting in there. It's really hard. I know what it's like to sit there. And not telling the truth, or they're telling their own truth, which is not your truth. And, unless you have it organized, like you're saying, and written out, you have nothing to defend your position other than your emotions. And that just doesn't hold up in court. You're not getting
Exactly.
analysis like that.
I know. And in high conflict situations where you have protracted cases, for example, and it's so unfortunate that people find themselves in this situation. But for example, when you're communicating with, let's say, an ex-spouse and there's issues going on or pending litigation, anything you can and say will probably be used against you. And they want you to wrestle in the mud with them, right? They want you to get dirty. They want to be able to go into court and say, look what she did. So you
Mhm.
have to really keep that in the back of your mind when you're communicating with them. So this is an exercise I also do with my clients. Let's say something comes up, they'll call me, they'll be upset. How do I respond? I'm like, well, how do you want to respond? And usually, like you said, it's emotion based. Well, no, I never said this, but. And I'm like, okay, I get that. But let's go back to your spreadsheet. Let's go look at the timeline. Let's pull some incidents or key facts that you've documented that can literally counter his narrative right now and just shut it down. And then we'll keep doing that. And after a while, it almost is like exercising that muscle. They'll send me a screenshot that they've done on their own. And they're like, look, aren't you so proud of me? I did it. I countered with facts. And I'm like, see, but you wouldn't have had those facts to counter with had you not done the work. And it
Mm.
just becomes such an invaluable tool for them because unfortunately, sometimes you need to reference that case hub, as I call it, numerous times a day. You
Well,
may need
Courtney, if you didn't give them the exercise to go do that, practice it. I think practicing it is so important, and teaching them how to go back. I love how you teach them to go back to the incident of memory, reread it, look to see where it fell in your timeline. And if you keep doing that, you're right. When you're sitting there to defend yourself, it comes naturally. And
Mhm.
that gives you so much confidence. So that is a great exercise.
And that's the thing, so much happens. I mean, even in my case, I forgot so much. And I went for an evaluation for custody issues 5 years post-settlement. So A, that's quite rare, but B, so much had gone on in those 5 years. So when I was pulling together the timeline, and that's when my mindset really shifted towards how I handled my own case and then has blossomed into this business that now I have. But I was going through all of my evidence and light bulbs were just going off in my head nonstop. I'm like, how did I forget all this? And I'm like, well, because you didn't document it. You didn't write it down, even though everybody said that you should have. Or I did, but it was half were on my notes, half were screenshots, half were saved on my computer. It's just disjointed. It was not cohesive at all.
Yeah.
So to your point, the more I familiarize myself with the things, when I went through the evaluation or I had to go into court after, it was so familiar to me. I didn't have to do tons of prep because I knew my case.
Yeah. All right, so to wrap this up, you all, this is great because we all know an attorney is going to, because they have a heavy caseload, they're going to, or for whatever other reasons we all want to say, they're going to pick your file up right before or the week before you're going to trial or you're going to mediation. So doing this prep work is what I'm hearing is what's going to make your attorney be better prepared. And it's going to be able to make yourself focus on the knowns and not the unknowns and come to a conclusion that you're going to be able to live with. But also, feeling good, because the only justice you're getting in this is the justice that you afford yourself. And that justice is what we're all hearing today, is documenting it, know it, and know when to use it, and know what the expected return of using that information should be for you. So
Yeah.
Courtney,
One last thing on that. I know there's a lot of talk about how the system's corrupt and they don't listen and they don't do the right thing. And family court, sometimes does make mistakes and judges don't do the right thing. But I will say at the end of the day, when push comes to shove, if you have evidence, black and white proof, and it's there presented to the right people, eventually it does make a difference. And let's say you get a bad ruling, that's why there's the appeal process. And I don't want to say that you have to appeal because I know that's costly and time consuming, but facts do prevail in court at the end of the day. A lot of people go into family court based on emotion, and that's where I see people really coming out on the losing end.
yeah, but just remember, it's the facts, knowing the facts and what the result of those facts could be, because sometimes facts don't get you anything in divorce. Right. So know what fact, again, I'm going to circle back to, and we do this with financials all the time. what data we're getting together, for what is the purpose and what's the expected outcome or the return on that. So great information, a great need here. Courtney, how do our listeners find you?
So I'm on Instagram, Courtney Gilmartin. My profile is public. I also have a Monarch Consulting Group on there. It's a smaller page. I don't do much with it right now. I get a lot of referrals. You can also find me on my website, monarchconsultinggroup.com. And I usually get back to people relatively quickly. I do free 15-minute consults right now. So yeah, people can find me. I'm usually all over Instagram. I'm pretty accessible there.
I love Instagram.
That's great. And thank you all for listening. And if you are listening, please share this with someone who you may feel would benefit from this conversation. Join our MDS community, a free supportive space where you can listen, learn, and ask questions as they come up without pressure. We host live Q&A events and more, and you'll find those links in the show notes. So Courtney, again, thank you so much for sharing your expertise and for shedding light on the area of divorce that so many people struggle to navigate. Until next time, our listeners, please protect your peace and let knowledge be your power.
Thanks for joining us on another episode of We Chat Divorce. We hope this episode was informative and supportive on your divorce journey. If you're looking for more support for navigating divorce with confidence and clarity, head over to mydivorcesolution.com for more podcast episodes, divorce events, and resources for your divorce. We'll see you back here for our next episode.